covert legal war has been declared, and the battlefield isn't where you think it is. While the media distracts you with headlines, the Supreme Court has just issued a ruling that signals a massive shift. A 6-3 decision has come down, but do not be fooled. This is merely the opening salvo. The real fight for the AR-15 has quietly begun, not on the Senate floor, but in the shadows of municipal courtrooms and city council chambers across America. At the dead center of this conflict is the AR-15. It is the most popular rifle in this nation, owned by millions for defense and sport, explicitly protected by the Second Amendment. But right now, through a seemingly insignificant city ordinance and a lawsuit flying under the radar, a devastating legal trap is being set. This is a mechanism designed to place millions of law-abiding gun owners in immediate jeopardy. This isn't federal overreach. It's a localized insurgency by governments operating below the threshold of national attention, banking on your ignorance until the gavel falls. The stakes are catastrophic. If this legal strategy takes hold, your AR-15, or any semi-automatic rifle you own, could be rendered illegal in your specific municipality, regardless of what the Supreme Court says. This is not fear-mongering. This is a cold analysis of the legal facts. If you value your freedom, you need to understand the machinery being built against you right now. While the country was fixated on Washington, the City Council in St. Paul, Minnesota, executed a maneuver that could shatter Second Amendment protections nationwide. They pushed through an ordinance mandating strict registration and severe restrictions on AR-15-style rifles. This was not a standard ban on future sales. This is a retroactive compliance nightmare designed to corner current owners. Submit to a government registry or become a felon. There was no public referendum, no transparent debate. This was a unilateral decision made to bypass the electorate. Gun owners were given zero warning and zero recourse. The statutory language mirrors federal confiscation proposals, but deployed locally. A single violation results in ruinous fines or incarceration. This is the first strike in a calculated legal offensive. And understand this: the ordinance was engineered specifically to provoke a lawsuit. That lawsuit has arrived, and it is a Trojan Horse headed straight for the highest court in the land. The case tied to this operation is Grant versus Rolla. It sounds innocuous, but it is a weaponized legal argument. The city is defending its restrictive ordinance by utilizing a fear-based legal standard. They are arguing that the mere presence of these firearms increases perceived risk, thereby justifying the suspension of constitutional rights. This is a radical shift in jurisprudence. The city is positing that the AR-15 is uniquely dangerous, not because of mechanical function, but because of public anxiety. They are petitioning the courts to accept subjective fear as a replacement for objective evidence. If a judge accepts this logic, it establishes a devastating precedent. It means any city council, anywhere, can claim that community fear overrides your individual right to bear arms. Consider the ramifications. Your local government could ban your property based entirely on emotion and optics. Once a single appellate court validates this reasoning, the precedent spreads like a virus. This is the trap. It is set, it is live, and it is gaining momentum. Despite the hysteria, the AR-15 is not an outlier. It is the standard. It is the most commonly owned rifle in America, used responsibly by millions. The Supreme Court has already ruled that firearms in common use are protected by the Constitution. So, why is this assault continuing? The term assault weapon is being weaponized and redefined in real time. Local municipalities are claiming that cosmetic features, military-style aesthetics, justify stripping you of your rights. The courts are fractured on how to interpret the dangerous and unusual standard. Activist judges and councils are exploiting tragic events to bypass the law with emotion. The AR-15 is being targeted as a symbol. But the law cannot be allowed to bend to symbolism. If we permit this, we open the floodgates to bans based on scary names and media narratives rather than mechanical function. In the 2022 Bruen decision, the Supreme Court laid down the law. Gun regulations must align with this nation's historical tradition, not modern political panic. That ruling was supposed to be a firewall. It eliminated the old balancing test, where judges could weigh your rights against public safety interests. It forced lower courts to prove a historical precedent for their restrictions. The St. Paul Ordinance fails this test. There is zero historical tradition for banning a rifle based on its grip or the fear it induces in others. This is why Grant versus Rolla is critical. If this case reaches the Supreme Court, it will be the litmus test for the Bruen framework. The outcome will either obliterate these local bans or enshrine them as the new law of the land. St. Paul is not an isolated incident. It is a pilot program. Cities across the nation are monitoring this case. Some are drafting identical legislation. Others are waiting for the green light. They are all reading from the same playbook: leverage emotion, redefine terminology, and push local ordinances to the absolute breaking point of constitutionality. This is a synchronized effort. Local bans provide a testing ground, shielded from national outrage. Activists are urging cities to strike while Congress is paralyzed. The courts are issuing inconsistent rulings, creating a patchwork of liability. Most gun owners won't realize their rights have been stripped until the handcuffs are on. The strategy is obvious. Rewrite the Second Amendment from the bottom up, one zip code at a time. If the judiciary does not intervene, your rights will effectively vanish depending on which side of the city limit sign you stand on. For millions, the AR-15 is a symbol of liberty and a tool of defense. But to the opposition, it is political currency. This clash is being exploited to generate legal chaos. The victims are honest citizens caught in the crossfire. When legislators prioritize optics over facts, the cost is paid by law-abiding people who wake up to find they have been legislated into criminality. The consequences are immediate: widespread legal uncertainty, malicious prosecution for conduct that was legal yesterday, and local statutes overriding federal protections. Trust in the system is eroding because the rules are shifting beneath our feet. This isn't a sudden collapse. It is a slow, grinding erosion of rights through vague definitions and political warfare. Here is the most alarming aspect. The Supreme Court has remained silent on the ultimate question. Can the government ban a firearm that is in common use for lawful purposes? The lower courts are in chaos. The Ninth Circuit has upheld draconian bans. The Fifth Circuit has struck them down using the Bruen standard. We are seeing a flurry of contradictory injunctions. Now with Grant versus Rolla, the justices are being forced to confront the issue. This is not about one city in Minnesota. If the court accepts this case, the ruling will impact every gun owner in all 50 states. If the court remains silent, the chaos wins. New laws will sprout up overnight, each with unique restrictions and penalties. Without a definitive ruling, you face the nightmare of felony by geography, where your legal rifle becomes contraband the moment you cross state lines. You face the risk of felony charges for minor compliance errors. You face the threat of sudden enforcement raids. Without a unifying decision, the American legal system devolves into a patchwork tyranny where the Second Amendment is optional. The Supreme Court has dragged its feet, but the pressure cooker is about to explode. The conflicting rulings from the lower circuits have created a constitutional crisis. States are enforcing laws that are in direct violation of the Bruen and Heller decisions, daring the court to stop them. The core issues are now on the table. Does commonly owned still protect your firearms? Can subjective definitions of dangerous override the Constitution? And can cities suspend the Bill of Rights by declaring a public safety emergency? Justice Amy Coney Barrett may hold the casting vote. While she has signaled support for originalist interpretations, her rulings have been cautious. Chief Justice Roberts may attempt to narrow the scope to avoid a cultural firestorm, but this situation demands absolute clarity. Vague decisions will only empower anti-Second Amendment legislators to push further. This is not just another docket entry. This is the showdown that determines the future of civilian firearm ownership in America. Do not make the mistake of thinking this ends with rifles. The war on the AR-15 is a gateway. If the courts validate bans on firearms that are commonly owned and protected by precedent, the floodgates open for total regulation. Here is the trajectory. Bans on standard capacity magazines, turning millions into criminals for possessing a plastic box and a spring. Reclassifying semi-automatic pistols as assault weapons. Criminalizing standard attachments like red dots and lights. Outlawing specific ammunition types. This is a strategy of attrition. They are chipping away at the right to keep and bear arms by redefining the terms. Today, they attack features. Tomorrow, they attack intent. Eventually, they attack possession itself. Once the definition of legal becomes fluid, no firearm you own is safe. This is why constitutional scholars are terrified of Grant versus Rolla. It may have started in St. Paul, but the verdict will echo in every home in America. We are standing on a constitutional precipice. A single ruling from the Supreme Court could determine whether you keep the property you have owned for decades, or whether you are branded a criminal overnight. These are not hypothetical scenarios. The laws are written. The test cases are filed. The trap is set. The battle is not just in Washington. It is in your backyard, your city hall, and your local precinct. If one of these laws stands, the rest will follow with terrifying speed. You must take action. Ignorance of this shifting legal landscape is not a defense in a court of law. Do not assume your rights are secure simply because they exist today. The final chapter of the Second Amendment is being written at this very moment. If you are not paying attention, it will be written without you.